Hi, everyone. So today is all about Q&A. It is all about you asking me questions. Okay. So if you're joining me and you have immigration questions, feel free to put them in the comments and I will be responding to them. I did get some questions ahead of time, so I'll be going through those as well. So if you have questions, ask me. If not, then you can hear my answers to other people's questions. I always find that when people ask questions, someone else that's watching probably has the same question and it's just not asking it. So let's go ahead and get started. The first question is from Sue on YouTube. So Sue is asking, my friend filed for VAWA for herself and her 9-year-old son, but her son's father is a US citizen. Can he file for his son even though the mother has a VAWA application pending? The answer to this is a big fat yes. Okay. He can file for his son because that's his child and he qualifies to file for his child. The mother qualifies the child on the VAWA application. So the father, yes, can file for the child, even though the mother has a VAWA application pending that the child is included in. So basically, what will happen in this case is if the father files for the child gets a green card. When the VAWA is approved, she just wouldn't file a green card application for the child. Okay, so that's how that would work out. But yes, definitely, I always encourage people, like, you can have more than one application pending at the same time. Okay, you can have a VAWA application pending and a green card application pending. You don't have it doesn't have to be one or the other. Okay. Next question is from Instagram. Mona asks, my son is here undocumented. How do you go about applying for him? Well, it depends on um, what your status is. Okay. So if your son and how old your son is. So if he's undocumented, how old is he? If he's under 18, in some states, he may qualify for special immigrant juvenile status, depending on the family history, parent history, and all of that. If you are a US citizen or permanent resident, you can file for him. And then once it's approved, you can okay, I'm a permanent resident and he's 8. All right, Mona. So she updated. She said that she is a permanent resident and the child is 8 years old. So the child will not be accruing any unlawful presence, but you can start the I-130 process. However, it will still require the child to leave the US and go for a visa interview outside of the US, unless you become a US citizen first. Okay. So as of right now, you can file an I-130. Then once the I-130 is approved and there's a date for an interview, you can actually go with your child to the interview outside of the US. Once that's approved and you have the visa in their passport, they can come back in. Again, because he's only 8 years old, there's no unlawful presence, so he wouldn't need a waiver or anything like that. And if you become a U.S. citizen before all of that happens, then you can just file for him for a green card in the U.S. without having to leave for an interview. So those are your options there. Can Another one from Instagram, can a spouse file an I-730 for husband when her asylum application is approved, even though the husband is undocumented in the country? Yes. That's one of the things when it comes to asylum. Typically, the husband would have been included in the asylum application, and then, but if the husband was not included, you can definitely file an I-730 for them. Once they are approved, right, they will have asylum status. So they will have the same status as you. And someone that came into the US undocumented can have an asylum, um, even though they're undocumented. So that wouldn't stop you from being able to file the I-730. All right. So if you're joining me and you have any immigration questions, please go ahead and put them in the comments. I am really here just to answer your questions and help you out today. Okay. So ask me your questions. And while I'm waiting for more questions to come in live, people did ask questions ahead of time. So I'm going to be answering some of those as well. Okay. So, first question I have here is I just became an American citizen. What form or forms should I use to bring my underage child over? So, if you are a US citizen and you want to file for your child that's outside of the US, your first step is filing an I-130. The form I-130 is on the USCIS.gov website. And that is the first step, right? You have to prove that that is your child. So the I-130 is the form for that. And then you include the supporting documents showing that they are your child. So their birth certificate, DNA test, whatever you have to show that this is your child, you would include that. And then, of course, proof that you are a US citizen. And then you file that with USCIS. Once it's approved, it will go into the National Visa Center where you would complete a DS-260 for the child. Depending on how old the child is, you may not need a full affidavit of support for them. You may just need the 864W just to show that once they come into the US, that they will automatically become a US citizen because you are a US citizen. So it is definitely the way to go once you're a US citizen to file for your child. And like I said, Form I-130 is the form to use for that. All right. Next question from Abdul. My question is, in the I-130 application, have you ever previously filed a petition for this beneficiary? Do this apply to any type of petition like visiting visa? No, it does not apply to a visiting visa because for a visiting visa, you are not a petitioner, right? A visiting visa is the person that wants to come to the US is applying to the US government to get a visa to the US. If you provide a letter saying that you're going to support them, that is not you being a petitioner. Okay? That is not you being a petitioner. That is just you saying that you will provide them with a place to stay or that you will provide them money while they're in the US or pay for their travels. That is not the same thing as being a petitioner. A petitioner means that you have filed an I-130 before for this person. Okay? So you are the petitioner. So an I-130, an I-730, those are petitioner forms. An I-140 petitioner forms. If you're filing, if the person is coming to the US and you're just giving them a support letter or an invitation letter, that is not petitioning for them. Okay. You're just making it possible for them to apply and have documentation showing that they do have a place to stay or that they do have a sponsor in the US, but it's not the same thing as being a petitioner. I hope that answered your question. All right. So the next question I have here is my 2-year green card and one of my kid was approved in 2022. After 7 months, my remaining 2 kids were approved. Please, can I use one form to remove condition from our green card? So the answer to this is no. Okay. So in order for you to include your children in your I-751 application, basically you have your 2-year conditional card. Your children also have 2-year conditional cards. You can use just one I-751 form if your child got the 2-year card at the same time as you or within 90 days of you. Okay? Either they got the card the same time as you or within 90 days of you. This person, the other two kids got it 7 months after, so the other kids will not be able to be included in her application. However, they can file their own application. That's the key thing there. Just because they can't be included in your application doesn't mean they can't file their own application. The only thing that happens there is you will have to pay the extra fee. So if they're included in your application, you're only paying $85 per person because that's the biometrics fee. But if they are not included in your application, that means you have to pay the full I-751 fee for both of them. So I know that can be financially hard for people, but just make sure that you do file their application on time, because if they go over the 2 years without applying for the I-751, that is a problem. Okay. So don't let the financials stop you from filing it, because that will affect the kids in the long run. Hi, Kasmida. How are you? Thank you for joining me as always. All right. And then Sue has a follow up. My friend filed for VAWA for herself, and so is it okay for the child's father who is a US? Okay, so Sue, I did see your question when we started, and I don't think you were in here, so let me answer your question. Yes, the father can definitely file for the child. It's his child. It doesn't matter whether the mother has the child in her VAWA application. The father can still file a green card application for the child. And that's usually a faster process too. All right. Let's see. Instagram questions. What's the remedy in law if your wife was denied a B2 visa, visiting visa? There is no remedy in law. You need to figure out why it was denied, and then you can reapply, but reapply with more documentation that shows that the reason it was denied in the first place is not accurate. Okay. But that's really what you can do there. It's not about, you can't appeal a B2 denial. That's the main thing. You cannot appeal the decision. You can reapply, but you need to know the reason that it was denied in the first place. If you don't know the reason it was denied in the first place, you may just file the same application, she'll go with the same documents, and the same thing will happen. So you really want to start with, why was it denied? What were the questions that were asked? And how did she answer the questions? And then from there, figure out what could have been the issue. Is it that she didn't have enough ties? If you are in the US and you're a US citizen, just know it's going to be very hard for your wife to get a B2 visa to the US, because the US government knows that if she comes into the US with a B2 visa, you two can just decide for her to stay here and file a green card application for her in the US. So it is harder for the spouse of a US citizen to be able to get a B2 visa, but it's not impossible. You just need to know why it was denied in the first place and make sure that she is ready for the next interview. There's no appeal. It's just reapplication is the remedy in law. Okay. Next question. If I have a P3 visa but expiring in like a month, if I get a sponsor, can I extend my visa? And if extended, can I apply for a work permit and start working with a different job? So it depends on if the job is still within the same visa category, right? So P3 is typically cultural exchange in some way. So if you are still in the same thing, your new sponsor can apply for the P3 for you, a P3 extension for you, or a brand new P3 for you. Okay. So they should be filing to get you that P3 before your current one expires. Okay. Um, please talk to a employment immigration lawyer. So these business immigration lawyers, I handle mostly family based, helping people and their families come to the US, stay in the US, right? Yours is more of a business question. So you need to have your sponsor, you and your sponsor meet with a business immigration attorney that can look at your current status, look at the how much time you have left, and make sure that if you're filing an extension of status, that you are doing it on time, or if you are filing a new P3 application, that you are doing it on time. Okay, so make sure that you are doing that consultation immediately, because if you have a month left, you want to make sure that you're getting those applications in on time. All right. My husband is an American. Can he file an I-130 for me to be with him? Yes. So if your husband wants you to petition for you to come to the US, the first step is an I-130. Once that's approved, it's sent to the National Visa Center, and then they process the visa end of it. So it's not the I-130 is not the first and last step. It's just the first step. After the I-130 is approved, then it's sent to the National Visa Center, where you would do a DS-260, the affidavit of support forms, and upload the supporting documents. And then you'll be able to get a visa interview. And once you do your visa interview and that goes well, you will be able to get your visa to come to the US. So the I-130 is the first step, and your US citizen husband will be able to file that for you, as long as you two are legally married. Yeah. All right. So remember, if you have questions, put them in the comments. And as I am waiting for your questions to come in live, I am going to be answering questions that I received before this. Okay. All right. What evidence has to be provided that the relationship has continued after the divorce? My mom has been in my half brother's life for over 20 years and got divorced from my dad 6 years ago. Okay, she married my dad when my brother was under 18. We want to get the application started. All right. So, in those situations where it's a step parent, stepchild relationship, and there's already a divorce between the biological parent and the step parent, you want to show that there is a relationship there, which is, if you two talk on the phone, if you visit each other, pictures, messages, things like that. That's what we have used in the past. So you can use that to show the relationship. Okay, so whatever, communication, that's really the key. Are you communicating? Are you seeing each other? What is that relationship like today? And documenting that for USCIS. All right, let's see. Do you have to submit an I-864 when filing for two children as a US citizen? Thank you. Also, become a US citizen a few days ago through asylum by following your show. Oh, congratulations, Abdul. So it depends on if the children are in the US, right? And what status they're in. If they're not in the US, because I think, yeah, if the children are not in the US, you will need to file an I-864W. Okay. So that tells the US government that once they need to qualify for that. Okay. So if you're already at that stage where you're doing the DS-260 or if they're in the US and they have a green card, they're under the age of 18, right? All those things need to be in place for you not to need that 864. If they're outside of the US and they are, let's say, 14 years old and you're already at the visa, National Visa Center stage of things, you may be able to do the I-864W, because once they get the visa to the US, they would still be under the age of 18. They'll have a green card. They will be in your custody. Basically, they will meet the requirements for automatically acquiring citizenship from you. But if they come to the US after they turn 18, then no. Okay, so if they're already 18 years old, you will need the I-864. If they're under 18, you may be able to just file an 864W to say that they are going to automatically become US citizens. All right. All right. On Instagram, I filed an I-130. Is the next step adjustment of status? It depends. If the person is in the US, if the adjustment of status is approved and they qualify, I'm sorry, no. If the person is in the US and the I-130 is approved or pending and they qualify for adjustment of status, then yes, that would be the next step. If the person is not in the US, it's not called adjustment of status. They have to go through consular processing, which basically means you have to wait for the I-130 to be approved. And once that is approved, it's going to be sent to the National Visa Center, where you would then fill out the visa application and the affidavit of support. So that will be the next step. But if you're in the US and you qualify for adjustment of status with an I-130 filed, yes, you could. But remember, typically to file a adjustment of status with an I-130, you will need to be either in current status or be an immediate relative of a US citizen. Okay. All right. Next question. I filed for I-751 for 11 months now, based on cruelty. What is the next action that is expected to happen? Um, Nothing anytime soon. Okay. 11 months is not, for an I-751, 11 months is not a long time. I know that sounds crazy that, your application has been pending for 11 months, and I'm telling you that's not a long time, but it's not for an I-751. So basically, the next step, they may have you, maybe they already had you do a biometrics. The next step, the office, once it gets to an officer, right, it has to reach an officer. The officer may review it, have additional questions, send you a request for evidence, or schedule you for an interview. They may also schedule you for an interview after they get the response from the request for evidence. So from here, it just depends on how quickly it gets in front of an officer and when, what the next step the officer wants to take, either a request for evidence or go straight to an interview. Okay. Um, for people with an I-751 still pending and you already reached the 3 years of citizenship requirement for someone that's married to a US citizen, what I typically recommend is, if you are in that situation where you already meet the 3-year requirement, right? You already meet the 3-year requirement. You're just waiting for your I-751 to be adjudicated and approved. You can apply for citizenship as soon as you meet the 3-year requirement. Again, that's if you are still in a marital relationship with your spouse, meaning you have been living with your spouse, or you filed an I-751 based on abuse or cruelty. Right? In those situations, you're able to apply for naturalization. And one thing I will tell you, in most jurisdictions, the citizenship application is processed way faster way faster than the I-751 on its own. So for clients that we know have a strong I-751 application, we file their citizenship application as soon as they qualify, and that typically leads them to having an interview on the citizenship application. And what happens, and the trick there is, yes, you have um, yes, you have your I-751 still pending. Your interview for the citizenship will come first, but guess what's going to happen at the interview? The officer has to decide your I-751, right? They have to approve that first before they can make a decision on your citizenship application. So that's a way that you can kind of get your application, I-751 application process faster, because it's going to be, once you file the citizenship application, it's now going to be on the citizenship track. I know in my state, in Massachusetts right now, citizenship applications are taking about 8 months or less. So that means if someone has an I-751 pending, they qualify for citizenship, we file the citizenship application, they're getting an interview in like 8 months or less in some situations. And then not only are they getting their 751 approved, they're also getting their citizenship approved at the same time. So that's a way that you can kind of hack the processing time when it comes to that. All right. And yes, Mr. Tusk, I know. Your reaction to the time frame, completely understandable. That's mine as well. Okay. Um, Maurice on Instagram is asking, how can I move to the USA with my wife from Nigeria? It depends on if you have um, family in the US that's able to file for you, right? Um, if you have employment or investment visa options. So typically, in order to get status in the US, you have to have some form of either employment, business, investment, or family. Okay. So if you fit into one of those, then you need to explore those options. Investment for Nigerians right now, you're looking at $800,000 to 1.2 million in order to be able to get a green card through investment. If you do meet those requirements, then your wife will be able to benefit from that as well. Okay. So, Mr. Toss, yes, you can um, technically apply because you're applying based on cruelty and not on divorce. It's up to the officer to then make a decision on the cruelty part. I will tell you that unless, typically the officer wants some form of proof of the cruelty. I'm sure you have that, which is why you filed under that. The officer can also, so here's the other part of it. The officer may choose to approve it under the divorce waiver, if they don't approve it under the cruelty waiver, which is going to be the, you know, right? If the officer approves it under the divorce waiver, no citizenship, right? No citizenship in 3 years. Because you're already divorced, you may want to weigh that before applying for citizenship because it can go either way. All right. All right. So if you have any questions, please put them in the comments. I am here to answer your questions as we go through this. I do have questions that people sent me ahead of time or asked ahead of time. So I'll be answering those as well. All right. So next question I have here is, I filed an application for my 3 children almost 6 years ago. I never received an approval for them. what may happen. Okay. So here's the thing with applying for children. When you ask me, oh, I applied for my children, my first question is how old are they and are they married? Because that's going to decide how long of a process you're going to have. If your children are under the age of 21, it's going to be a faster process. Whether you're a US citizen or a permanent resident, that's going to be the fastest process. If you are, if your children are over 21, that's going to be the next fastest process. And then if your children are married, regardless of how old they are, they can be 18 years old and married, they will be the slowest possible way of getting status. So basically, if your child is over 21 and you filed an application for them, you filed an I-130 for them, the I-130 is just pending, it's been 6 years, just know that's normal. And I know that's not what you want to hear, but that is normal because there's no visa available, and there's not going to be a visa available for at least another 7 or 8 years. Okay. And because of that, USCIS is not going to prioritize those cases. So they're just going to let it go until it gets closer to the time that there's going to be a visa available, and then they'll make a decision on the case. There's no like, this is the processing time. There is, but when a visa is not going to be available for another 7 to 8 years, they're not going to prioritize those cases over, let's say, ones for children of US citizens, or minor children of US citizens, or minor children of permanent residents. Okay. So just know that's why that happens that way. And then if the children are married, remember I said married does not matter how old they are, they're going to be in this last category, which means if they are married and you are a US citizen, it's going to take like 14, 15 years. Okay. That's just the numbers right now. And that's the numbers because there's not enough visas available. All right. There's not enough visas available. So it's going to take that long. And if that's the situation, it is going to take some time for USCIS to look at it and decide the I-130. Because even if they decide the I-130, remember, you still have to wait for your priority date to come up. So for a visa to become available before you would then be able to apply for the actual green card. Okay. Okay. Why do people with TPS status have a problem re-entry to the US than people with asylum status? I'm not sure what you mean by that. Why do they so people with TPS status, in order for them to leave the US and be able to legally come back, they need to apply for advanced parole. If they do not apply for an advanced parole document and have that document approved before they leave the US, they're going to have a very hard time coming back to the US. Okay. Just because a country is designated for TPS does not mean that someone that's outside of the US from that country can come to the US. Okay. That's not the same thing. So a country can be designated for TPS. That doesn't mean that people from that country can just come to the US and have TPS status. TPS has a cutoff date. So every time the State Department designates a country for TPS, there is a cutoff date that the person has to already have been in the US. TPS is only for people in the US. So if the person is coming from outside of the US thinking they're going to come in and get TPS, that's usually not possible unless there's a redesignation. If someone is coming to the US and seeking asylum, which is not only something that's recognized in the US, but there is an international treaty when it comes to asylum where the US government is required to do a credible fear interview. So basically, a credible fear interview is a pre-screening to see if the person has real fear of returning to their home country. If after doing the credible fear interview, oh, I am so sorry. I've just been told that you can't hear me on Instagram. If that's, just let me know, please. I can always try to boost this. So if you can't hear me, just let me know, please. Um, but basically, if the person is coming for to the U.S. to seek asylum, there's a process for that. If they're coming to the U.S. to seek TPS, there's no process for that because they will not qualify for TPS. Okay, so that's the main thing there. If they are coming for TPS, they're not going to qualify for TPS because they probably already passed the cutoff date. And TPS is only for people in the US already, not for people trying to come in. All right. So, questions, ask me. And Abdul, I am so happy to answer your questions because some people have these questions and they don't ask. And now they have more information on the difference between TPS and asylum. So I am very happy that I'm able to answer these questions for you all. Um, if you have questions, please put them in the comments. I am literally here just to answer your questions, okay? All right. Question from Instagram. My I-290B was approved, but after that, no communication. So typically when an I-290B is approved, that means they will reopen the case. That probably also means USCIS is reviewing the case, okay? So they're going to now go back to processing the application. They're not going to contact you unless they need something from you. The approval notice for the I-290B is your communication to let you know that the case is being reopened. So it's completely normal not to get anything from them unless they want to send you, unless they need certain documentation, they'll send you a request for evidence. Okay. But that's normal to not have an immediate communication from USCIS. What is the 10-year law for green card? Can you be more specific? Okay. So are you talking about people being able to get a 10-year green card versus a 2-year green card? Or are you talking about, the 10-year bar before someone can get a green card? So just let me know, if you can let me know in the comments what you mean by that. I'll be more than happy to answer that question. Okay. Kumar is saying it's been 4 years. In that situation, please contact USCIS, and you can also contact your congressperson. So sometimes they're able to get USCIS to give them more information than they may give you. So this is after after a year, getting congressional assistance is appropriate. So I would suggest talking to your congressperson and see if their office, so most of them have a part of their office that handles USCIS or immigration inquiries. So definitely reach out to your congressperson, see if they can provide assistance for you. Okay. All right. So I do not see a clarification on the 10-year law for green card. So I'm just going to answer it in two ways. Okay. I'm going to answer it as if the person is asking what's the difference between 10-year and 2-year card. So if you are applying for a green card based on marriage and okay, here's the people who have been living in the US for 10 years and only have TPS, is they allowed to get the 10-year green card? So living in the US for 10 years does not lead to on its own, does not lead to a green card. You may be talking about cancellation of removal, but that only comes into play if you are already in deportation proceedings. So you're in immigration court, you have 10 years of residence in the US, you have a US citizen child, spouse, parent that will suffer extreme and unusual hardship. If you were not allowed to stay in the US, then the immigration judge can decide to approve you cancellation of removal, which will then lead to you being able to get a green card once the cancellation of removal is approved. But it's not something that you can apply for outside of immigration court. Okay, you must already be in immigration court and have the 10 years before you're in immigration court, unless in certain exceptions, and then you'll be able to apply for that if you meet the requirements. But it's not something that you can just apply for. And I never recommend anyone putting themselves in immigration court just to apply for that. Okay? Because again, it's up to a judge. And if the judge denies it, now you have a deportation order. Okay? So I hope that answered your question. Um, all right. So, any other questions, feel free to ask. If you're watching this on the replay and you have questions, or you're joining me and you have questions that come up after this, go ahead and go on my YouTube page and ask me questions, okay? People, feel free to ask me questions there, because I do on these Q&A sessions answer those questions. Okay, those are the questions people said ahead of time that I'm answering, so please feel free to ask me. All right. All right, so the next question, this is a question I get all the time, and as you can see, a lot of the questions are, how long is this supposed to take? Why is it taking so long? And a lot of the time that my answer is going to be completely real with you, which is, it's completely normal, right? Depending on where you are, depending on what type of case you have, depending on your situation, it can be completely normal for your case to take longer than you expect. Okay. So here's a question. I'm from Ghana. I'm married to a Black American. 2021 case was approved. So their I-130 was approved in 2021 and accepted by the National Visa Center in August of 2023. And she has not heard anything since then. Okay. She has not heard anything since the MVC said her case was accepted. Here's the thing. Okay. Here's the thing. That is normal for Ghana. I hate to tell you this. Ghana right now, it is taking 2-3 years to get an interview. And if you heard that, she applied in 2021, was approved the I-130 in 2021, but did not complete the MVC stage till 2023. So her time frame, if she did the MVC stage in 2021, would have been 2021. But because she didn't complete the MVC stage till 2023, she's going to be looking from 2023. Okay? So that processing time, right? That processing time is going to be from 2023, not 2021. So when you're waiting for an interview, you have to look at, when did you provide all the documents that's needed from the MVC? When did they say your case is accepted? And when did they say that you're now in line for an interview? That's the date you're looking at, not when the I-130 was approved, because the I-130 approval date does not determine when you will be in line for an interview. So it's really the 2023, when she completed the MVC stage, that's when she was actually put in line. So if someone was approved in 2022, right? If someone had their I-130 approved in 2022 and completed the MVC stage in 2022, they will be ahead of her that completed her MVC stage in 2023. So that's why the MVC stage is so important. The quicker you're able to get through it, the faster you're going to be in line for an interview. Okay. And now, what typically will happen is she'll be looking at people that applied in 2020, in 2022, wondering why they getting an interview before me, and not realizing that it's not about when your I-130 was approved, but when your case was accepted by the MVC. Okay. So that's my PSA for everyone. If you're at the MVC stage, get through that as quickly as possible, because you are not in line for an interview until you complete that. And anyone that completes it before you is ahead of you, even if their I-130 was approved after you. All right. Next question. What happens when your spouse has work permit and do not work? Does it affect his green card processing? Secondly, if a filing my taxes, should I add my spouse? So, two part. First part, no. Just because you have a work permit does not mean you have to work. I can tell you, I have applied for a work permit for a 3-year-old. The 3-year-old is not looking to work, right? But the 3-year-old wants a social security number, needs a social security number. So having the social security number is typically why you want to apply for the green card, the work permit, because that will be most likely processed faster than the green card. You can at least have your social security number, be able to work if you want to, but it's not a requirement. It will not affect the green card process. For the second part of your question, this is very timely because we are in tax season. You should be filing your taxes together. Okay, married filing jointly, married filing separately. Those are your only options. Okay, if you're living with your spouse, your only options when you go to file your taxes is married filing jointly or married filing separately. You are not head of household just because she's not working. Okay, you are not head of household just because he's not working. You are married filing jointly. All right. And I will tell you, married filing jointly is typically better than head of household in most situations. So take that. That's why it's the standard deductions and all of that. Okay. This is not tax advice. I'm just saying, for immigration purposes, they look at your filing status. They care about your filing status. And if you're filing a single head of household when you are married and you are living with your spouse, that's a problem. Okay. And that's going to make your, that's going to cause your whole thing to look suspicious to USCIS as well if you're not filing with your spouse. So that's the fastest way to get suspicion on your case, is if you file as single, but you're saying that you live with your spouse, that you're married to your spouse and all of that. Like, it's it's hard to come by, okay? It's hard to overcome that. All right. Oh, you are very welcome. I saved you $200. I'm glad I was able to do that. I'm not sure how I did, but I'm very glad I was able to do that for you. All right. Is it true that children of U.S. citizens get interview appointment faster than spouse in abroad? Okay. So I'm guessing the U.S. citizen children and the spouse are both abroad. If the children are under the age of 21 and are married, they are in the same track as the spouse of a U.S. citizen. Okay, they're on the same track. If they're not, if you're over 21, clearly that's a completely different place. But children under 21, unmarried of a U.S. citizen, and their spouse, the spouse of a U.S. citizen, are on the same track. So It's not that they're going to get an interview faster. It's just the embassy also, so I say that, but in reality, the embassy looks at what is the most efficient way to move these cases along also. So when it's minor children, when there's documentation of the relationship right there, they're not questioning paternity, they may choose to put those give those interviews faster, or find like a 10-minute slot to put that appointment in, versus a marriage base that may need more time. So it's just, it depends. Okay, it depends, but they should be on the same track. But in reality, the officer may find like, they only really need to see the child, ask the child one question, and approve the case, right? So they may put them in a slot that's like 10 minutes. Okay. So it's not a faster track, it's just depending on how the embassy is managing their um, caseload. But I will tell you this. A nice little trick is, if, let's say, you filed for a spouse first, or you filed for one child, and one child's application. So I'll use real life example. So we had a case where we filed for 3 children. 2 of them were MVC approved their stuff faster, and then there was one that they still were like taking their time in accepting the application. The 2 that they accepted their stuff immediately got finally got an interview like 2 years later, 2 or 3 years later. They got an interview date. The other child still doesn't have an interview date. They weren't included in the interview notice, but it's the same case. It's the same parents, it's the same petitioner, it's the same everything. So we were able to ask USCIS, where we were able to ask the embassy to expedite that one child's case, so that they will do an interview for all 3 children at the same time, saving themselves headache and more time that they would have had to figure out a date to schedule the other child, do an interview. They can just do all the children at the same time. And guess what? They agreed to that. So that leads me to think, if, let's say, you filed for a spouse first and then later on decided to file for children, if it's the same petitioner, if, let's say, the children are the spouse's children as well, the embassy may be able to schedule them all at the same time. And if they're not scheduled at the same time, you could possibly ask them to schedule the appointment at the same time. So it's just stuff we've tricks that I've learned in my years of doing this. So I hope that helps you. I have a cousin who is a Briton who wants to live and work in the USA. What does he have to do to legally immigrate here? So he needs to figure out if he has. So unfortunately, you cannot file any sort of petition for your cousin. He will need to meet certain requirements. Okay. If he wants to work in the US, he should be looking at US employers that are open to sponsoring their employees. There are job postings where they will say, sponsorship not available, or we're not willing to sponsor, but there are employers that are willing to sponsor employees. And also, if he has certain expertise or is top in his field, he may qualify for other types of visas. So he should really explore, if he doesn't have the family-based options, he should really explore the business and employment-based options. Okay. So, but let me say this though. If he is fresh out of school, doesn't have any work experience, it's going to be very, very hard to find an employer that is willing to sponsor him. But the more experience he has, the more things he has going on that will benefit a US employer, that is not just like his physical presence in the US will benefit the US employer. Because remember, A U.S. employer can hire him in Britain and have him stay over there. But if he wants to live and work in the U.S., he should be looking at employers that are willing to sponsor employees. So that would be my advice there. All right. Oh, great question. Lottie the Blessed. Listen, listen, this is a great question. Can you remarry while your I-360 is pending? The answer is no. No, no, no. And I'll tell you why. So an I-360 is based on either abuse by a U.S. citizen or permanent resident spouse, or you are the widow of a U.S. citizen, right? In those situations, you can apply for an I-360. However, once you get married, once you remarry, the I-360 goes away. Okay. That is one of the few things that will cut off an I-360. Right? If you get divorced while the I-360 is pending, not a problem. But if you get married to someone else, or even the same person, if you get remarried while the I-360 is pending, while the VAWA application is pending, your VAWA application will be denied. So, but if the person that you're now remarrying is a US citizen that is willing and able to file for you to get status in the US and you're qualified for adjustment of status, that is a path that you can take as well. I've had it go both ways. I've had clients where they were ready to remarry, they met someone, they fell in love, they're ready to move on with their lives. But they still had the VAWA application pending. What did we do? We drew the VAWA application and filed their green card application through their spouse. Okay, their US citizen spouse. So that is a possibility. It's just if the person is not a US citizen and they're not about to file for you, then that's not the move to make because your I-360 will be denied. Yes. So she's asking, so can you withdraw the I-360 and remarry to your US citizen spouse? Yes. Yes, you absolutely can. Typically, I suggest filing the green card application through your US citizen spouse before withdrawing the VAWA application. But yes, you can certainly do that. So I have a few clients that are in the same that are doing the same thing right now. So it is completely normal. And one thing that I know people worry about is, oh, how is USCIS going to look at my new marriage if I file VAWA with my old one? Blah blah blah. No, they're just going to look at it the same way they look at every other um, every other case. Like if you were married before, they will look at your previous marriage regardless. So that's how they're going to view it. They're not looking at, oh, well, you applied for VAWA before. No, they're not looking at that. So your case will be just fine as long as you meet all the requirements. And yes, when you are ready, please use a lawyer. And if you don't know, I am a US immigration lawyer. I'm not sure if I even introduced myself, but I am Lillian Chugur. I'm a US immigration lawyer, and I help my clients get green cards and citizenships for themselves and their families using the US immigration law system. So that's why I like doing these lives where you can ask me questions, because this is what I do on a daily basis is help people get green cards. So that's that's why I do these lives. And thank you, Mr. Tusk. I am very grateful for your kind comments. Oh, if you want to book a consultation with me, you can do it directly on my website, lilylegal.com/contact us, and you can pick a time and a date that works best for you. You can also call my office at 508-443-1788. I believe all my links are in my bio in Instagram. And then if you're watching on Facebook or YouTube, all my contact information, including the direct link to the scheduling, is on the description of this video. Okay. Lottie, please feel free to schedule a time with me, and I will be more than happy to give you that cost breakdown. All right. All right. So I don't see any other questions. So I'm just going to do a last call. For questions. So if I don't see any questions, we are going to end this here. I am so glad I was able to do this today, and you all joining me. Thank you so much for asking your questions. These Q&A sessions are truly, truly important. And if you are watching this and you are getting value out of this, please feel free to like this video if you haven't done so already. And if you have questions, you can still put them in the comments, okay? I'm still here until it says that the live stream has ended. I am still here. So I'm still paying attention to the comments. So go ahead and ask your question. And then while I'm waiting for that, I get so many questions that I can keep going with more questions. Okay. Um, all right. So this is a question that if if you're watching this on Facebook or Instagram, you probably it's not a problem for you. But um, is it necessary that your spouse's name on Facebook will be the same as in I-130 or their passport? No. I love this question because it's one of those things that um, people just don't know. And that's one thing I tell people all the time. Like when you're watching um, my lives and people are asking questions, you may have watched my stuff like 20 million times and you already know the answer, but there's someone that's watching for the first time that doesn't know the answer. So I'm going to take some time and answer that question, which is your Facebook page, your name on Facebook does not have to be the same as your actual name for immigration purposes. If your spouse is outside of the US, so if you're applying for a DS-260, a DS-160. So those are the visa applications for people that are outside of the US. Those applications ask you for all of your social media accounts for the past 5 years. Okay, this goes for children. This goes for if you're filing for a parent. The parent has to disclose all their social medias for the past 5 years. Whether they're using it, whether they lost access to it, it doesn't matter, right? You need to put that in. So even though the name doesn't have to be the same as your actual name, it still needs to be disclosed in those situations. So that's the great thing about the world we live in. USCIS kind of understands how social media works and that most people do not use their full name on social media, but they still want you to disclose it. Okay. So that's where that would take place. And then I also have a recent question all about social media, which is should we create a social media and start using it while we're going through our marriage green card process? And my answer to this question is a no. Okay. If you do not already have a social media account, if you do not already consistently post on social media, Don't just create it because you have a green card application pending or you plan on filing for your fiance. That's not going to help you. Okay. So don't create things that you're not already using. If you're already using your social media and you're already posting about your spouse, about your fiance, whoever, great. We can use that as evidence, but don't just manufacture evidence by creating this account because guess what? Guess what? Um, when you put it as evidence, USCIS can see your name. They can go and look it up and see how long the account has been open. And if they look and the account has only been open like a month before you filed, that's going to be suspicious. Okay. But if it's an account that you've had since you were in high school and now, it just documents your life through the years, perfectly fine. Keep using it. Okay. Um, but I do tell people your social media can jeopardize your case. Okay. So just be careful what you're posting on your social media while your case is pending or even before your case is pending. You can also make your page private because if you don't and USCIS does decides to investigate you and take their time and investigate you, they can see what you post. All right. And not investigate you as in like there's something wrong with your relationship. Sometimes social media is the fastest way. They can just go on Facebook, put in your information, maybe your email, maybe your phone number, something, and you pop up. Okay. That's just the easiest thing they can do before they start having like the fraud department go to your house. They may just start with your social media. Okay. So just because they're looking at your social media doesn't mean that they are suspicious. They just want to see what you're posting. And if you are posting your spouse, what kind of things are you posting? So for example, if you're applying for a fiancé visa and they go on your social media and they see that you are posting pictures and it says that it was your traditional marriage, they're going to deny the fiancé visa because a traditional marriage in most places counts as a marriage. So, and I've seen this happen multiple times. So that's why I tell people your social media, post your stuff on it. If you don't want USCIS to be able, or the embassy to be able to see what's on your social media, make it private. That's all I can tell you. Make it private. Okay. All right. So I think that is all the questions. Thank you so much for joining me. This was truly fun, and I look forward to seeing y'all next time to talk more immigration. Remember, if you or someone you know needs an immigration lawyer, you can reach out to me by going to my website, lilylegal.com, or calling my office at 508-443-1788. Thank you all. Have a great weekend.